Welcome to the Business Restructuring Podcast with Parkins and Rubio.
Hello, everyone, and welcome to the Business Restructuring Podcast with Parkins and Rubio. Lenard, Parkins, and Charles Rubio are corporate bankruptcy and financial restructuring attorneys with offices in Houston and New York. They represent companies, lenders, and stakeholders in complex restructurings where litigation risk and financial pressure intersect. My name's Sean O'Connor, and today we're starting the series From Defense to Offense, Strategic Playbooks for Companies Under Pressure, with a conversation about the early warning signs that litigation and financial pressure are beginning to threaten enterprise value, and how leadership teams can recognize the inflection point before control begins to slip. So, a lot to get into here. Lenard, good to see you.
How are you?
I'm doing great. Mr. Rubio, Charles, how are you?
I'm doing well, Sean. Thank you.
Now, are you guys in separate? Are one of you in Houston and one of you in New York right now?
I'm in Houston.
Yeah, I'm the New York partner, and Lenny is the Houston partner of the firm.
Good to good to know. Good to know. Let's talk about a situation. What it looks like typically when litigation first begins to shift from a contained dispute into something that starts threatening enterprise value. How do you recognize that?
Yeah, I mean, I think most companies probably anticipate some form of litigation occurring, and I think the typical way that they would try to handle that is through insurance. So you would normally have, your insurance, you'd have your brokers. If you get sued, you call up your insurance company and hopefully they appoint, competent counsel for you to represent you in that state court suit. And, you as the managers get to move on and focus on your business because you bought, insurance to cover that litigation dispute. So we're talking about situations where the litigation exceeds either the insurance or is not covered by the insurance or something else, where it's kind of like penetrated that shield, that initial shield that companies would have in place to protect them from litigation risks that would jeopardize their enterprise value.
My first experience with this was in 1983 when I first represented Continental Airlines in its Chapter 11 case. And Continental was confronted with massive labor litigation between its unions and management. And that labor litigation overwhelmed the company, took company management all the time to deal with. And Chapter 11 became an alternative for the company to deal with the litigation, that it couldn't deal in the state court or federal court or in arbitrations or in mediation, in a way to take control of litigation away from the plaintiffs, away from the movements, away from the labor, and to take control of it and put it in management's hands and deal with it through a Chapter 11 case. And in fact, eliminate those contracts, control the outcome, and control the amount of damages that were available to the plaintiffs in those cases. So that was the first time I ran into it as a strategic option when the company realized that litigation and continued litigation was a no-brainer to move from.
Yeah, and with respect to litigation starting and you seeing it kind of snowballing and having this effect, the kind of litigation that Lenny's talking about is that type of litigation where you might have one labor dispute, but then it becomes 2 and 3 and 4. And that is a similar phenomenon that occurs in other kinds of litigation too, product liability and things like that, where, you might anticipate, okay, we're going to have some product liability issues, but then it starts snowballing in on that topic. And you end up having to deal with multiple pieces of litigation, possibly in multiple different courts. So you're not just addressing one, but it might be 2, 3, 4, and then it just snowballs to a larger amount, like labor issues.
The situation also is centered on questions of class actions, where class actions are brought by purported putative classes representing many people have aligned or similar claims, and alternatives to dealing with large class actions available when management wants to either eliminate the possibility of a class certification, eliminate the plaintiff's lawyer's opportunity to make a lot of money in a class action, and take control. The whole idea about the issue of changing the dynamics from defense to offense is changing who controls the dynamics of the litigation. And that's
Ah,
really one of the major topics and themes that run through everything we're going to talk about.
got it.
And that's
Got it.
another instance where you have litigation snowballing is, when you see class counsel out there trying to aggregate claims and make a
Mm.
class and advance the litigation on that front as well. And to Lenny's point, if you act fast enough, you might be able to, you know, take take care of it at the early stages where it doesn't have as much momentum and you can use bankruptcy to your advantage. So, we'll be talking about those things later on. But these are the types of things where you start to see the snowball effect, whether it's, you're this opposing counsel, class counsel trying to aggregate claims for a class action, or just multiple kind of similar litigation coming in on the same topic.
So one of the main things we're going to talk about is control,
Hmm.
changing the dynamics of control, and the issue of timing and when to exercise the right move and the chess game. And timing is very important. It's very critical in the context of what we're going to talk about and the strategies you're going to implement. And strategies can be made or lost by ineffective use of timing.
Yeah, yeah, that's I'm looking forward to get into some of that for sure. Um, the in terms of early signals, obviously, finances, right? The legal spend, one of the earliest signs that, okay, wait a minute, things are things are scaling up here. What changes when litigation costs begin approaching or even exceeding the underlying exposure?
I mean, that probably means it was probably poorly handled already. Like
Mm.
part of this is, there's an overlay here of settlement as well, right? With every litigation, there's an overlay of settlement, and
Hmm.
you need to find the right amount. That's a possibility too. So, if litigation costs just keep blowing up and they exceed the amount of the underlying liability, it likely means that you just didn't take advantage of a settlement opportunity really, early on, which should be the amount of the liability. So that's why I'm saying it might be just poorly managed from a litigation perspective if you're really spending more than the liability of the litigation.
Or
You could.
more plaintiffs and more lawsuits may be piling on. You may have a number of lawsuits that you might settle, but more have been filed and more pile on, and therefore the magnitude of the problem grows as more plaintiffs and more plaintiffs' lawyers get involved and start bringing more litigation in various venues around the United States. If you have lawsuits pending in 20 or 30 different states, it's a real difficult issue to manage and becomes a very expensive problem to manage if identical lawsuits or similar lawsuits filed by in venues all over the United States by various plaintiffs.
And even that's part of the strategy. I think we'll get into that as well, which is, when you settle, like management teams may be eager to settle. They may be thinking, okay, I can get this one off my plate if I settle, and thinking through a broader Chapter 11 strategy. That person may be a useful player in implementing a Chapter 11 plan, because at the end of the day, all Chapter 11 is essentially a large negotiation between the company, the debtor, and all of its stakeholders, which include the creditors, and you're trying to do a deal. The good thing about Chapter 11 is you can essentially force a deal on them under the right circumstances. So you always have that backdrop.
And the issue Charles talks about is control. You control the venue, you control the situation. And Chapter 11 gives a company and its defense counsel an opportunity to really take control and say, we want to settle, we want to litigate. How do we want to structure this? Timing of doing it, ultimately getting out of Chapter 11 with a plan, which is usually an agreement among the parties to settle the claims. All of that takes over and takes precedence and basically shifts control to the company. But by federal law, in order to sort of dictate the terms and tempo and structure of how the outcome ends up.
Got it. The you mentioned timelines and the importance of timing, and I know litigation timelines can stretch for years, all the while liquidity shortens. How does that how does that mismatch between those things begin creating pressure on the business itself?
Yeah, look, when you start getting into a case, the litigation costs may not be that extreme. I mean, you're first answering a complaint, and then, you likely start doing discovery, and then you get experts involved, and, you start seeing the costs start ramping up. So, from initial perspective, the litigation may seem manageable for some time, but that as you progress with litigation, you have these additional expenses, and that's another area where Chapter 11, facilitates the process and makes it more efficient to resolve those claims without all these extra costs of just facilitating the litigation process going forward. You can just use the tools of Chapter 11 to facilitate all that.
It's not just timing. That's a big issue. And timing costs money because litigation and discovery continues, and all lawyers who represent companies know that they have to incur this. But the timing also is important in the context of the motion practice that's going on in the litigation. There'll be motions to dismiss, motions, more importantly, possibly motions for summary judgment with respect to certain major legal issues and stuff like that. And those kind of circumstances and the timing of those motions and the anticipated result coming out of those motions. Okay. If you win a summary judgment with your defense counsel, it means there's no summary judgment in favor of the plaintiffs. That means you're going to trial on that issue. That trial may be very expensive, very protracted, and require much more discovery. For a plaintiff, you win summary judgment, you win a big piece of the case. And that is something the defense counsel have to consider in the context of when you exercise certain strategic options, if you think that's going to be a consequence of a plaintiff's motion for summary judgment, for example.
When when a judgment becomes a real possibility, right? Flexibility narrows. How do executives and boards recognize the earlier decision point when a more proactive options are still available?
Let me give you an example. We have a circumstance that just came in our office where somebody was going to trial in a very plaintiff favorable venue.
Mm-hmm.
They were selecting a jury, and before we even got consulted, they filed Chapter 11 to invoke the automatic stay to stop the trial from going forward. The plaintiffs took that to the bankruptcy court, and the automatic stay was lifted within 24 hours, and the trial went forward. So that was an action that was taken too late. That was a bad timing decision. And I talked about timing. That was a bad timing decision. The opportunity to go into Chapter 11 and take control of the situation was lost by that time. So that's an example of when you have lost the opportunity to take advantage of Chapter 11 because of bad timing, just a bad timing.
So, Lenard, just to clarify that, had they gotten to the Chapter 11 filing sooner, it would not have been as likely to have been the stay to be lifted.
Well, let's say if the company had come and sought advice earlier on, here's some things that could have happened. Number one, if the company thought that a judgment was going to happen, it was going to be a big judgment, I bet the company kind of judgment. Okay.
Yeah.
And you decided to file Chapter 11. What are the consequences? Number one, there's an automatic stay. The litigation stops. Number two, there will not be a jury trial. If it's not a personal injury and wrongful death case, there will be a trial in front of a federal bankruptcy judge. Number three, you will get to pick basically your opportunity to pick venue of what court and what judges might try the case. And number four, because there's no jury trial, there ain't going to be any punitive damages available to the plaintiffs. So those are the options you had. And also five, you can do a plan of reorganization and come up with a way to pay out any potential judgment that might arise, okay, over time and keep ownership of the company. Those are the options that were available early on. When you wait too long, as the time goes against you, your availability to access those options diminish.
Yeah, Sean, I mean, to answer your question like head on, the answer is yes. If you file earlier, you're likely not to have the stay lifted, which is all the consequences Lenny said, which is that litigation is dealt with in bankruptcy court. So if you wait until the jury is impaneled and, they've already started the trial, that's likely a time where the judge will say, well, let that court go ahead and liquidate the claim. But if you're well in advance of that, then it's the domain of the bankruptcy court to liquidate that claim, and it has all the advantages that Lenny just said, which is no punitive, no jury trials done in front of a federal judge that's specialized in these kinds of matters.
Yeah, right. And as we alluded to at the beginning, just that it's a more proactive stance versus defensive and reactive.
It makes the plaintiffs and the plaintiffs' lawyers puts them on the defense instantly when you file a Chapter 11, and you strategically know how to maneuver through the Chapter 11 system to take advantage of that opportunity and give all the advantages I just discussed that Charles and I just talked about.
Yeah. And so with just a couple minutes of time we have left here, not, there's no, one size fits all approach, but I'm curious, given how long you guys have been in this business, what are the most common mistakes that your, eventual clients make? Like, I guess, like, the message you're cleaning up, is it just waiting too long to be in contact with the right attorney? What's your experience? What would you tell people listening today? Like, hey, make sure you do XYZ, or don't do XYZ.
The first thing I would say is to dispel the issue that you have to be broke or insolvent to take advantage of Chapter 11.
Oh.
Bankruptcy. Number one, you do not have to be insolvent. You don't have to be, quote, broke to take advantage of Chapter 11. You can take advantage of Chapter 11 if you have major pending litigation. It's you likely to be adverse against the company. Judgments pending against the company. Bad contracts you need to address, okay, and fix with respect, like the labor contracts Continental had to deal with.
Mm-hmm.
Okay. Pending anticipated class action litigation. All these things are available to you, okay? And you don't have to be insolvent to take advantage of them. You have to be just knowledgeable that Chapter 11 is available to fix financial problems that a company has, okay? And because of that, the aura of Chapter 11 being, failure of business rather than a strategic affirmative alternative for companies really needs to be dispelled, and over the years has been dispelled by virtue of successful Chapter 11s like Continental and others that have demonstrated that you can get over public saying, well, I'm not going to fly on a bankrupt airline. Well, no, every airline has filed Chapter 11. Everybody flies on them. All this stuff has happened over time. So that's a big hurdle. Once management gets over that hurdle, it can look objectively at the options available that Chapter 11 provides versus where they are in state or federal court litigation. That's a first hurdle to go.
I would say the right time to call like a corporate defense bankruptcy lawyer is once your normal defenses are not working for some reason. So like I said, every company probably anticipates some level of litigation. Like they would have
Sure.
that line item in the budget, they'd have certain insurance, they'd have certain controls over that. And once that starts exceeding the parameters, once you either have some anomalous litigation that's not really covered by insurance, once you have too many folks it might not be covered by the insurance anymore. Like once there's an anomaly in your litigation strategy, I would say that's the right time to call a corporate bankruptcy attorney to determine whether Chapter 11 is the right option. Like Lenny said, you don't have to be in financial distress. You just have to be trying to resolve financial matters. And Chapter 11 is a reorganization. So these companies live on and so they emerge from the bankruptcy case. So they don't die. They're not liquidated. It's just a strategy to employ. So I would think that that's the right time to call when your normal defenses are not working anymore.
Great. Yeah. It's interesting. It's counterintuitive. Like you said, I mean, you wait too long, management gets consumed, you end up insolvent and your company does go away. Whereas if you use the strategic tool in the way that it's intended with the restructuring, you come out the other side, hopefully, better, stronger, you live on. So,
when management wakes up and goes to their office every day or gets on their Zoom calls every day to deal with their business, and the top line of their business is how are we going to deal with discovery schedules and the litigation versus how are we going to make money? Okay. You want to start to think that something's wrong here. The balance of where we're focused is a little wrong. We need to change the dynamics of what we're doing here. That's certainly something you need to think about.
Love that. Yeah. Just whatever your assistant comes in and gives you your to-do list. And if the first 1 and 2 items are dealing with litigation, pick up the phone.
Well, what's my schedule for discovery being deposed and document production this week?
Right. Okay. Well, listen, Lenard, Charles, we're out of time, but I know we'll talk more. It's a complicated and fascinating bunch of topics. So thanks for being here today, and we'll see you soon.
All right. Thanks, Sean.
Thank you.
That's it for today's episode of the Business Restructuring Podcast with Parkins and Rubio. If you'd like to learn more about Lenard Parkins and Charles Rubio, you can visit the website, parkinsrubio.com. And be sure to like, leave a review, and subscribe so you don't miss the next episode in this series, From Defense to Offense, or From Defense to Offense, Strategic Playbooks for Companies Under Pressure. I'm Sean O'Connor. Thanks for tuning in.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.